Hi there, this is Mark News, and this is Bankruptcy TV Episode 2. I'm coming to you today from Westward Law, and the topic today is which chapter is the right chapter for me. If you're looking for a bankruptcy, you want to understand the different chapters that are available to you as a consumer and make the decision as to which chapter you might want to use to get out from under the debt that is burdening you. So the two chapters that are mainly available for a consumer are Chapter 7 and Chapter 13. And the reason we call them chapters is that there's the bankruptcy code. It's the laws that govern federal bankruptcy. And so there's a title. The title is 11 USC. And then there's several different chapters in that title. And Chapter 7 covers all of the rules and laws that govern the type of bankruptcy in the Chapter 7. And then Chapter 13 in that same code covers all the rules that govern that type of bankruptcy. And there's other chapters. There's a Chapter 11, which you typically hear about with businesses. Those are businesses that are looking to reorganize typically. And there's also Chapter 12, which governs bankruptcies for fishermen and farmers. And there's also Chapter 9 and Chapter 15, international bankruptcies, municipal government entities that are filing for bankruptcy. But those are outside of the scope of what we're here to talk about, because you're a consumer most likely if you're watching this video, and you're interested in primarily Chapter 7 and Chapter 13. Chapter 7 is what is the most popular bankruptcy for people. The reason is it's shorter and it's a little less complex, and it's cheaper to get into typically. A bankruptcy attorney is not going to charge as much because it doesn't take as long, and it's usually not as complex to get a Chapter 7 done. Chapter 7 is called a fresh start bankruptcy, as opposed to Chapter 13, which is a wage earner's bankruptcy or a repayment bankruptcy. The main distinction between the two is, as I mentioned, the length of time that it takes to get through them. Chapter 7 is about a 3.5 month process to get through it. Chapter 13 is 3 to 5 years. So it's a much longer process, and what's going on during that longer process is that you're making payments, and you'll work with your attorney to set what will be a reasonable payment that can get approved through the court and through the trustee, and you'll be paying that payment for 3 to 5 years. So it doesn't sound like a lot of fun, but sometimes people go down that route, and there's different reasons why. So we'll talk about some of those reasons today. But you're wondering, if I had the choice between a 7 and a 13 and I qualified for both of them, wouldn't I want to choose a 7? And the answer to that is most likely yes. But there are these other considerations that people have. So first, I want to talk about what are the requirements for the couple of chapters we're talking about. And in a Chapter 7, in order to be able to get into a Chapter 7, you have to be, standard requirement. You have to be an individual living in the United States, or you can be an entity, a business in the United States. You have to be doing business in the United States, or you have to own property in the United States. So you have to have some contact with the United States to file bankruptcy here, and that makes sense. You must have also not had any previous Chapter 7 bankruptcies in the last 8 years. So most of the time, that's not a problem for most people, but every once in a while, someone's filed a Chapter 7 and had a discharge many years ago, and so you have to look at when was that date? When did you get that discharge, and how long ago was it? So you can determine whether Chapter 7 is even available to you. Also in Chapter 7, you need to have income that is either below the average for yourself or your family in the state that you live in. So that number is going to vary significantly based on where you live. I work in Washington State, and in Washington State, for an individual, so a family of one, a household of one, the average income is roughly $59,000. So if you have income less than $59,000 then you qualify, for Chapter 7. You don't have to do any other checks to make sure you qualify. If your income is over that number, that average number, then there's another requirement. So you have to then look at this test, and it's called the means test, and it comes into play when you're over that average income level. And the means test was put in place back in 2005. This was done when creditors, which they don't like to see a lot of people filing for Chapter 7 when they have the ability to pay. And so, of course, they lobby Congress. And Congress decided to revamp the bankruptcy code in 2005 fairly significantly. One of the major changes they put in was this Chapter 7 means test. And so now you have to, if your income is above that level that we talked about, you have to pass this means test in order to qualify for Chapter 7. And basically they're trying to determine whether you have the means to pay or not. And they do that by calculating your income and all of the different expenses that you have, and there's allowable expenses, so maybe you pay for things that are much more costly than what they allow you, and you have to make concessions for that. But it's a complex calculation. If you find yourself in that particular circumstance, you want to be talking to a bankruptcy attorney to help you through it. But if you fail the means test and you're not able to pass that, then you're considered to be, filing a Chapter 7 would be considered abusive. And it's abusive to Chapter 7 and the purpose for the Chapter 7, which is to allow people to discharge all of their debts, but they can't have the ability to pay the debts that they want to discharge. If you can't pass the means test, then you're looking at a Chapter 13. So those are the requirements for Chapter 7. In a Chapter 13, they're a little bit different. As I mentioned before, in a Chapter 7, you can be an entity, so you can be a business. You can be an LLC filing for bankruptcy, or an S corp, or a corporation for that matter. In Chapter 13, none of those entities are allowed. You have to be a person. You have to be an individual. So that's one of the major differences with 13. You also in Chapter 13 can't have had previous bankruptcies too close to the time when you're wanting to file this new Chapter 13. Now, the Chapter 7 rule, which we talked about, is 8 years. In Chapter 13, it's a little bit more relaxed. So in Chapter 13, there's also the requirement that you not have had another bankruptcy too close to the time when you want to file the Chapter 13. The time frames are shorter. So for Chapter 7, it was 8 years. For Chapter 13, it's 6 years. So you could have filed Chapter 7, 6.5 years ago, and still be allowed to file a Chapter 13 now. You wouldn't be allowed to file a Chapter 7, but you could file a Chapter 13. There are other reasons. If you'd filed a Chapter 13 6 years ago or 5 years ago, you could probably file another Chapter 13 at this point. So it gets a little bit more complex when you're dealing with a Chapter 13 and whether the previous bankruptcy you're looking at is a 7 or a 13. But the rules are pretty substantially relaxed from the Chapter 7 hard and fast 8-year rule. The last requirement for Chapter 13, and this is one that doesn't come up that much, but it does with people that are high wage earners. So they have an income that's relatively high, but they also have a lot of debt, and they're looking at bankruptcy. Here, you've got to really take a look at how much debt you have, and you have to categorize it. So you have to look at how much secured debt that you have, so your houses, all your cars, all your secured loans that are tied to collateral. So those secured debts need to be totaled up. And then if they equal more than $1.84 million, so it's a big number. But if you have secured debt that is more than that, then you can't qualify for Chapter 13, and you're looking at a Chapter 7 maybe, or Chapter 11, which is not even a topic for another day because that's very rare. It doesn't happen very often. So we'll leave that aside. But you got to look at the secured debts, and then you also have to look at the unsecured debts. And if you have debt more than $395,000 roughly that is unsecured, so these are all of the lines of credit maybe that you have with particular businesses, but it's not secured, it's not tied to collateral. All your credit cards, those sorts of things, those are unsecured debts. If those unsecureds add up to more than $395,000, then you're not eligible for Chapter 13. So you'll be looking elsewhere for other options. So those are the requirements for 13. We went over the requirements for 7. Now you know what they both are. If you qualify for both chapters, how do you decide? What are the factors you're looking at? It's a tough decision. I mean, which direction do I want to go? Most people, if they have both paths available to them, will most likely choose 7, but not in all cases. So here's the things that I think you need to look at to make that decision. And of course, I can't make it for you. I'm just giving you information so that you can assess your own situation today. But these are the things that if you meet with a bankruptcy attorney, they're going to help you to determine which chapter is probably in your best interest. And they'll do that relatively early on, most likely in their initial consultation with you, which in most cases will be free. So I recommend that you seek out a bankruptcy attorney to help you make the decision. But let's go over some of the factors that I would advise you to look at. One is you want to look at your income, and you want to look at your monthly debt. So how much your outlay is every month. Are you making ends meet? Are you not able to make ends meet? Are you not paying some of your bills so that you can pay other bills? Those sorts of things. And if you were able to get rid of some of your bills, most likely the unsecured bills, could you still then make all of your secured payments? So you want to assess that. It's a big important part. Second, you want to look at all the assets that you have and all of your, if you own a house, maybe you own 2 houses, you own a few cars, 3, 4 cars, you have cars for your kids. You want to keep all those things. If those assets all have loans against them, they're collateral on secured loans, then in order to keep all of them, you possibly might need to be looking at a Chapter 13. That's not to say that you couldn't do a 7, but some of those assets might not be protected if they don't fall under certain levels of equity. If you have, say, an expensive car that's a $20,000 car, but you only owe $10,000 on it, now you have $10,000 worth of equity in that car. That is tough to protect. So if you're looking to keep that car, then 7 might not be the way to go. You might be wanting to go down the path of a Chapter 13. You also want to look at any assets that are valuable to you. So family heirlooms, things that you don't want to lose, and that they are relatively valuable to others as well. Some of those things might be protected with your exemptions, and exemptions are another topic for another episode, but typically an individual or a family can protect several $1,000s worth of household goods or value in the car or jewelry or tools of the trade, things like that. And there's different limits depending on where you live and what exemptions are available to you. You can protect a certain amount of equity in your home if you own a home. But once you get above that, if your assets in that particular category add up to more, now those assets are exposed. And in Chapter 7, you run the risk of possibly having to give up some of those assets. And so you might lean towards a Chapter 13 if you've got these family heirlooms or maybe collections that you have, like stamp collections, coin collections that are worth quite a bit of money. Other things like artwork, expensive artwork, things that don't get a lot of protection in the bankruptcy exemptions. So if you want to keep a lot of those things, you're going to have to be looking at a 13, most likely. So those are the first two considerations for you. The third one is that you need to be thinking about the length of time that a 13 will take you to get through it. So it's a 3 to 5 year. So you want to take a look at whether or not the length of that plan versus a 7 is something that you can take. Is that something that's going to be even palatable, or you're going to be able to handle a 3 to 5 year plan? Because if anything goes wrong during the 3 to 5 years, and of course things do go wrong over such a long length of time, then you might not be able to make your payment, or there might be changes that have to be made to modify the plan. So things can happen, and maybe sometimes people can't make the payments and their case will be dismissed and they won't get the discharge. So these are things that you want to consider. The last option, the fourth option, is to take a look at which debts you have that might not be dischargeable in a Chapter 7, but they would be dischargeable in a Chapter 13. And this would steer some people to a Chapter 13 because you want to get rid of as many debts as you can. And if a Chapter 7 bankruptcy won't get rid of all your debts, maybe a Chapter 13 will. But of course, you're making that payment over the course of that length of time. But sometimes that payment doesn't have to be that much. Don't think about it as this might be a several $100 or $1,000, worth of payments. It can be a smaller amount. It all depends on your own circumstance. But if you have back taxes, for instance, so income taxes are one of the main things that people look at that they have a hard time discharging in Chapter 7, but they are more lenient about discharging taxes in Chapter 13. So you might want to look at that as well. But if you don't have any non-dischargeable tax debts, taxes, etc., then the fourth factor here is not that big for you. So these are the major factors you want to look at, and hopefully with the help of a bankruptcy attorney, you're gonna take a look at Chapter 7 versus Chapter 13, and you'll come to a decision as to which is best for you. I'd be happy to speak with you about it if you're struggling with that decision and you're looking to possibly hire a bankruptcy attorney. I work in Western Washington in the North Puget Sound area, and we'll have the phone number and the website here on the screen. But thank you, and I hope you enjoyed the video.